Hi, I want to welcome everyone. I'm Dr. Stephen Procopio. I'm the president of the Public Affairs Research Council of Louisiana, better known as PAR. We're a nonpartisan, a nonprofit state policy research organization and watchdog. And today we're going to talk about ethics. And I really want to, before we start, thank our sponsor, the Louisiana Independent Pharmacy Association, who represent your local community pharmacies for making this possible. Um, Ethics is a part of what PAR always cares about from our very beginning. Uh, and just to let everyone know that the Louisiana Board of Ethics has gone through many changes this year. The board was expanded from 11 to 15 members. The process for picking their selection changed. Uh, this year, lawmakers, with the backing of Governor Jeff Landry, rewrote the ethics code, campaign finance laws, and disclosure rules for public officials and candidates. And the board also chose David as their new administrator. So a lot of changes going on. And this is a way we can try and help reach out to citizens and let them know what's going on. Um, so with that, we have the two, I think, perfect people to talk about this. We have Jason Amato, who is the chairman of the Louisiana Board of Ethics, and we have David Bordelon, the state ethics administrator. So we have sort of the board and as well as the staff. So there's no question they can't answer.
Mhm.
So before we start, a few questions or a few broad uh, format issues. Uh, we're going to start with a few broad questions. So I'll ask the first one or two, then Melinda will start, but then we're going to turn it over to the the participants. What questions do you have? Put those in the Q&A, and then Melinda will ask those. So she will probably format in a way, especially if there's multiple people coming in to try and make the questions, sort of clear. So please put everyone you want in there. One thing we always tell people, try to put the question in as soon as possible, because once we get started on a conversation, questions tend to pile up. And we always try to get in all of them that we can. But if you're toward the end of the queue, sometimes we can't get there. So with that said, so first of all, thank both of y'all for being here. I really appreciate this.
You're welcome. Thank you for the opportunity to participate.
And I'd like to start off. I think this is an important because I don't think that many people know. They maybe know there's a board of ethics, but not that much about it. So let's talk about, first of all, what are each of your roles in ethics administration? So why don't we start? David, you tell us what the administrator does, and then Jason will follow up with you and sort of about the role of the board in general. So David, tell us what all you'll do, and and don't take a half an hour.
Mhm.
Sure. Most of uh, individuals' experience with us is probably taking the training that everyone has to take every year, but we actually do a lot more than that. We enforce, of course, the Code of Governmental Ethics. Um, we handle Campaign Finance Disclosure Act and lobbying provisions. And as ethics administrator, I oversee the office on a day-to-day basis. We do the operations of the decisions that Jason and the board make, and how they instruct us to handle those matters. And so I am more of the, like I said, day-to-day face of the office. If there are issues, we handle them here. And then anything that any decision making goes to the board itself. But we do handle more than just the training that everyone takes. So it's quite a broad area of law that we cover.
Okay. And then we'll probably ask a few more follow-up detailed questions as we go through. Mr. Chairman, tell us about the role of the board and particularly as distinct from the day-to-day operations, what's your job?
Sure. Thank you. And welcome, everyone. For us as a board, we get an opportunity to work each month with David and his fine team. They provide us with a number of staff recommendations on the cases that come in. And we as a board review the cases and, in a nutshell, decide either we accept the staff recommendation or we may ask for additional information or even make a recommendation on our own. So again, it's working in partnership with Mr. Bordelon and his fine team and all for the residents of the state of Louisiana.
All right, great. All right, so that's a good entree and start to give people a general idea of what's going on. I'm going to turn over to Melinda. We have a few questions that we worked on in advance, but again, if any of y'all have questions for our panel, please put that in the Q&A, and the sooner the better. Melinda?
Okay. So obviously the legislature rewrote the ethics code earlier this year. And part of the stated impetus for that, legislators said they'd heard repeated complaints about the board being too strict on public officials for minor violations, such as late filing of disclosure reports or campaign finance documents, and filing charges over what they considered sort of frivolous things. So, Jason, from your perspective, has the board changed its approach? And I know you've been chairman of the board just this year, so short time period. But has the board changed its approach to how it levies fines and penalties and handling of charges because of those concerns raised by legislators?
So I think first point is, the legislative, they set the rules and the regulations and the laws, and we enforce them and all. We have 15 members on the board. It was increased from 11 previously and all. And I got to tell you, it's a lot of experience and talent on this board. A number of attorneys, several former state representatives, three retired judges, and myself. So the I think the vast knowledge across gives us an opportunity to review the cases. Of course, most of the time we're taking the recommendations from the staff, but for me, I guess my guiding principle is I look at it from a common sense perspective and a compassion perspective. David will tell you, and he's shared it with all of us, especially the new members. If you look at it from a whole, maybe 2% of the all of our elected officials and appointed officials maybe come before us, and I don't think anybody wakes up in the morning and says, "Yep, today's the day I'm running afoul of the ethics laws." I think we live in a busy time and all, and so we work, take all the information that's gathered through David and his team and really review and say, okay, where do we go forward? And the main thing is, how do we prevent a reoccurrence? That's that between the reoccurrence point and then I think the public expects disclosure. So how do we make sure that's being accomplished too?
Okay. David, how does the staff determine fines and penalties and what it recommends to the board? And how much leeway do y'all actually have in the law?
So we start with the law allows for the ethics. It allows violations up to $10,000 and then one and a half times any sort of ill-gotten gain. So if someone got, $1,000 check that they weren't supposed to, we could get a potential penalty of 1,500. What we do as staff is we go back through previous cases to compare them. We try to make recommendations that are consistent with prior cases that the board has already approved. That way, it's this board and each iteration of the board are consistent as to how they apply the at least the standards of the ethics code, and then they can take in any mitigating factors into account. And so we try to summarize that for our board members. We recognize they have a very difficult job. They have to take in all this information and enforce it in a way that, like Jason says, accomplishes the purposes of the goal and the purposes of the act, and then, keeps disclosure in mind, keeps transparency in mind. And so it's a balance of enforcement and transparency. And what we as staff do is we try to make sure that that's consistent. And so we base our recommendations on that. The board has the authority to, like Jason said, to disagree with the staff. They often do. That's not a problem. But it's often reasoned. We have board members that, might feel passionate about certain issues. And so as long as something is reasoned and logical, I think it's a good basis for making decisions.
Jason, do you have any sense of how often y'all disagree with the recommendations of the staff on these kind of things?
Yeah, this will be my first year on the board. It's not that often. And really, I think the times we've questioned is more of seeking further understanding. And one of the questions I always ask, as David said, is what's the precedent from years past? So we do have a number of members who got 3 and 6 years experience. So we want to make sure, what was their line of thinking when a similar situation occurred? And for us with the new members, okay, how do we proceed, taking that into account and making sure that we're consistent and we're not any unintended consequences by a challenge.
Okay. David, I feel like a lot of people probably don't know the process for how to file a complaint if they may not even really know that there is a complaint process, but if they have concerns about an official's conduct, whether that's, a possible violation of nepotism restrictions or conflict of interest laws or disclosure
Mhm.
rules, any of those things, how do they report and file a complaint or a concern with your office?
So it's real easy. There's no formal complaint form or process. It simply has to be in writing from a citizen of the state of Louisiana. They can do that via upload to our website. They can fax it in, mail it in. The only thing I can't do is take it via email. I often get people email me just random information. I tell them, okay, put this in some form and send it in. But that is as simple as it is. And once it comes to our office, it gets assigned a docket number, and then you are updated throughout the process. Our staff attorneys review each complaint that comes in. If it's something that concerns one of our laws, and then we obviously make a recommendation to the board one to either pursue an investigation or perhaps to close something. Maybe a complaint isn't quite doesn't meet all the allegations, and so from there, obviously, once an investigation is started, it goes through our full investigative team and then comes back to the board as an investigation report. So the complaint to start this process is very easy. It simply we need enough information to determine who the complaint is about, what their position is as a public servant, and kind of what the allegations are. And as long as we look at the dates within the last 4 years, because that's our look back period, we can proceed from there.
And the complaint, just to be clear, can be anonymous or it can be like someone who gives their name as part of that complaint.
Correct. So the statute and laws, there's different types of complaints. We have sworn complaints where someone gets a complaint notarized. We have regular complaints where they just provide their name and address, and then the board does have the ability to take up a matter on its own accord by 2/3 vote. So if we get an anonymous complaint that the board thinks might actually have merit and we can identify who the individuals are, then the board can take that up as well. Now, of course, with the anonymous complaints, we can't inform you as to what's happening. We don't have anyone to notify. So it's a little bit harder for us also from an investigative standpoint to verify the information. So we have to be a little bit more careful with those. But if you submit a regular complaint, you'll get notifications, you'll get contacts from our investigation team along the way so that you're involved in the process.
Okay. We have a question from someone asking about they understand that a number of members must vote to send a matter for investigation, but what is the standard of proof that the board needs to send a matter to investigation? I don't know
So
which one.
I'll take it. Under the new law, the statute says that it requires a 2/3 vote and the board to find a probable cause that the allegations may lead to a violation. So what we're looking for is a public servant. We're looking for enough information in there to believe a violation may have occurred, and it's something that we can investigate further. So that's the standard that we look at those with.
Okay. And this
Yeah,
leads,
Melinda, I might
yes,
add, when you
yes.
look at our board also, with a number of them that are practicing attorneys and the three retired judges, they really do a good job of seeking evidence that we have a strong case to move forward or not.
So you have three retired judges. Do you know
Mhm.
how many lawyers you have?
But
Oh, I have to count them.
yeah, I have to count, but I think six. Yeah, so
Okay.
That
yeah.
sounds about right.
Mhm.
Okay. So that's a lot of expertise.
Mhm.
Um, so this leads to sort of a broader question that somebody has filed in the chat as well, asking about what happened in the legislative session with the ethics code. So I'm not sure who wants to take this, but I guess if we could talk through what changes were made to the ethics code and campaign finance laws in terms of the process for handling complaints and investigations.
I know
Sure,
David
I could
thinks about it
probably
in his sleep, so you can go ahead, David.
I could probably walk you through a little bit better. So, of course, as Jason mentioned, there was probably about this time last year, there was a number of criticisms and concerns from elected officials and stakeholders and people that have been kind of involved in the process. And so, I think there was an attempt to kind of corral some of those concerns and build in some protections for the public servants who might be going through our investigation process, for example. So from the ethics standpoint, that bill that came through the legislative process and the act that resulted, the focus of it, I think, was mostly procedural. There were a few substantive issues that were addressed, but the bulk of it was procedural issues. And so we now have steps. One, they included that new language of probable cause. They kind of borrowed that from a criminal law realm. That's not really something that exists in administrative law, but and so they have added in steps, for example, respondents who are under investigation now get copies of any subpoenas that we send out, any interrogatories. Those and the answers are provided to them prior to the end of the investigation. They are also being given a copy of the investigation report, and they're given the opportunity to at least to present a position paper or make an appearance before the board in person at one of our meetings, which is different because those opportunities have not always been there, at least to make an appearance. We've always encouraged people to give us position papers, but making an appearance at an executive session discussion has not always happened. So allowing that to happen, I think, has given some of the participants an understanding of what the board does and what information they're looking at. And I think it gives them, maybe whether they agree with the result, at least a belief that their voice is being heard in the process. And that's what we're trying to make sure. We haven't, we're trying to put some rules into place to make sure that those things happen every time. And so it's the bulk of those changes, I think, were aimed at that sort of understanding of what the process is and how it affects the respondents, essentially. Campaign finance, there was a little different. There was much more substantive issues there, basically rewrites of the Campaign Finance Act and new sections. But they also took a lot of those procedural issues and put them into campaign finance as well. So we see a lot of the same things as far as respondents being able to provide position papers and participate in the process and that decision making before the board makes a final decision if they think a violation has occurred. So so far we've gotten positive feedback from people that have appeared before the board. They've expressed their thanks to the board for being able to make an appearance and kind of present their case. I think the board members have appreciated hearing how things come about in certain contexts in their own words. And so I think it's important to put a face to the issue and then we let the board make that decision. So a lot of the changes we have had to deal with, obviously with campaign finance, also involve the forms that our candidates use because there were so many substantive changes. Just about every campaign finance form has been updated. So what we're hoping is that as those candidates use those forms, they see that they are, I guess, easier at least to understand possibly. I know we're dealing with accounting and finance records, but we tried to make it so that if someone is, this is their first candidacy, they don't know exactly what they're supposed to be doing with this, that they can follow step by step at least what to report to us and then go from there. So it's been a lot of work since those acts have gone into effect to make sure that the users and the respondents and everyone that's involved in the process is seeing the benefits of those new laws.
And just to be clear, for the sort of the process piece of it, for both ethics violation and campaign finance violation allegations, there are 2/3 votes that the board has to take now to sort of move through this process a couple times, correct?
Correct. So previously, it required 2/3 vote to send a matter to an investigation under either ethics or campaign finance, but then just a majority vote to, say, file charges if there was a violation that the board believed we have evidence of. Now it requires 2/3 vote both on the front end and the back end. So if there's perhaps some concern about legal standards, say, or just the strength of evidence that we have obtained, there can be a discussion, and it takes 10 board members to agree that there was a violation and to proceed. So um, it I guess reaffirms that decision that this is a board decision, and kind of takes away a little bit of that, maybe any concern that, any one particular board member may be steering a matter one way or another. It does take 10 board members, both at the front end and the back end, to move a case.
And Jason, let me ask you this question. How do you ensure that accountability and transparency kind of remain key to ethics enforcement in the state amid all the changes and sort of the questions about what the changes might mean? I know one of the board members has worried that, the changes could hamstring ethics enforcement in some ways. So how do you think about it in terms of what has been rewritten?
Yeah, so first of all, Dave and his team have done a great job taking the changes and really working hard to get our forms and the procedures and all adapted to that and all. I think I have not seen that in my year so far and all, and I think some of the changes were good. Perfect example, look what last month you had what two governors races, Virginia and New Jersey. They were nationwide. I don't think any time soon you're gonna start seeing the governor's race or other key state level races where it's just the state of Louisiana. So when you got outside groups coming in now, we recognize there was some gaps between federal election reporting and our own state reporting. Some that's been closed now. So I think by that alone, we'll see better transparency from everybody. And I think it's a little clearer now. We do have to do an education piece, and David and his team have been doing a great job of outreach to make sure that the PACs and all the officials are aware, hey, this is the changes and this is how you comply. And at the end of the day, it's you as the candidate have a responsibility to comply with the rules for transparency. You owe that to the state of Louisiana, our residents.
Okay, David, we have some technical questions that I'm
Oh
sure are
boy.
going to be directed to you, which is
Okay.
somebody asking what prescriptive period applies to violations like failing to file a report?
So campaign finance and ethics have two different prescriptive periods. So if we're talking about a campaign finance report, it is typically 1 year from the date the report is filed, if the violation is contained within a report. Otherwise, it's 3 years from the event. So, for example, an excessive contribution, if someone reports that they got, a $20,000 contribution, that's excessive. That's contained in a report. We should see that and be able to enforce that within a year. In situations of campaign finance where there's, something maybe hidden, say a contribution in the name of another, where we won't know that just by looking at the report. It would take a complaint. We have 3 years from when that occurred to look back. So 1 in 3 years is what we look for in campaign finance. And then ethics, all of the financial disclosure forms that our public servants have to file, board members, elected officials, we can look back up to 4 years. So from the date that that report is filed. So it's a little different depending on which one you're looking at, but campaign finance is the one where those most often come up. Is, we're looking at when the transaction occurred, say a contribution, an expenditure, and going from there at least a year.
Okay, off the top of your head, very impressive.
Yeah.
We also have a question about what is the general timeline from when a complaint is referred to investigation until contact is made to interview the complainant?
So that'll really depend on the type of case. What we say is our rules and regulations say that a notice of investigation goes out within 10 days of the board meeting. That goes out to the respondent. Then what we aim to do is within 30 days of that, if we haven't gotten a response from the respondent, we try to reach out to maybe the agency that is at issue to get some documents. At that point, it becomes the investigator's decision as to when they actually contact the complainant. Sometimes we may need information up front as to who to contact and exactly what offices we're dealing with. So we'll reach out to them a little bit earlier, but within any matter, within the first, I would say, 90 days of an investigation, they should have at least received some sort of contact from the investigator to say, hey, we're working on this. We may be in contact in the future. But it's really up to them as to what information they're trying to get and how the timeline falls as to when they get that. We want to be careful, it's easy to say a complainant, and these are confidential and privileged, but we're also dealing with a lot of small town agencies, parishes talk. So we want to be careful who we are talking to and what information is out there so that we're not, one, harming that person's reputation by, someone thinking that they're a complainant, but also we can rely on the information that we're being given from the agency that it hasn't been affected by that decision. So it really depends. What we try to say is within the first 90 days of an investigation that there's been at least some contact.
Okay. There's a question that's asked that I think I can probably answer. Somebody's asking what happened to the proposal that certain complaints would have to be filed in person in Baton Rouge. That bill, as I recall, actually didn't make it through the process. It stalled in the Senate. But it does make me want to ask Jason, did the board take a position on that bill that was going to sort of remove confidentiality around complaints and change how people could file them? Was that something y'all had concerns
We
about?
we had some concerns. We didn't take a formal stance on it, Melinda, but you know, I didn't think it was fair for if someone from Lake Providence had an issue would have to drive all the way down to Baton Rouge just to make a complaint and all. And and this, I mean, we're doing a Zoom call right now. Technology is so far advanced and all. So I was glad to see the Senate put a hold on it. And again, 1 year in, I haven't seen an issue, and I think we will continue to monitor the situation. But again, I thought it was the right decision not to proceed with that.
Okay. Someone is referencing a recent report that we put out with ethics data we got from David, indicating that only about 12% of matters that were the complaints that were received from 20 to 23, about 12% led to board findings, whether that's charges, fines, caution letters, any of those things. Is there any concern that all the changes made to the various ethics and campaign finance laws will somehow impact or lessen the number of complaints that could lead to findings because the process has been
And
changed?
for the record, we didn't plant that question about the PAR report, but just
We did
thank y'all
not,
for getting this data on it.
Right.
So,
but I was going to highlight it.
Uh, Perhaps I could start with that one, and Jason could chime in. But I think a lot of the concerns dealt with that bill that we just mentioned that kind of died. Otherwise, the process for submitting ethics complaints and how we handle our investigations is still the same. So I don't have this big concern about some sort of chilling effect, and I think we're going to see probably a similar number of complaints. Um, what I will say is, we deal with a lot. We receive a lot of complaints that are not simply issues under the board's jurisdiction, and so that's why I think when you see that 12%, we have to gatekeep and kind of filter out a lot of complaints that perhaps are open meetings laws or public records laws or simply harassment. If someone is not nice to their constituents, but um, I don't have a major concern about going forward. I think what we're trying to do and what the board has kind of given us leeway to do is um, put some parameters in place to make sure that the complaints we get are sufficient to meet that probable cause standard, to make sure we're going into an investigation with enough information that we're not fishing. We know exactly who we're dealing with and what we're looking into. And so if as long as we keep those kind of guidelines together, I think our process will remain the same.
Jason, on that question, I feel like I recall the board having, some board members having concerns that the changes to the process gave more ways to slow the process down and perhaps somebody could try to run out a clock as opposed to facing any kind of penalties or charges. Is that something that you're worried about with the final iteration of the bill?
I'm not worried. It's one of the conversations we have with David and his team around the prescription and time period to make sure, is there, how much time do we have left on this particular case? And we recognize that that threat exists, but we try to work through it exponentially to make sure that we get to a point where that doesn't occur. So it is a real a concern, but we're moving forward to make sure that we address it properly.
Are
And
you updated on a fairly regular basis about the status of cases from the staff to know sort of where things are going?
Sure, I mean each month, David and his team will give us a rundown if there's a couple of cases that they're still working on, but recognizing hey, at next you see it at the next month's meeting, and this is the reason why because we're getting ready to run toward the end of the time frame, so we got to move forward.
Okay. We have a question from someone asking if during the investigation process, criminal violations are uncovered, is it referred to a prosecuting agency?
So this ethics code does allow the board after a hearing to refer a matter to, a local district attorney or perhaps or some sort of prosecuting agency. What we often find out is they are already aware of whatever the issue is before we even get it. We often interact with their office first. So I can't, there may have been one or two, and I'm thinking of the past that we've even had inkling that maybe this is an issue. But usually what happens is we have already gotten the complaint includes that information from sort of a criminal investigation or, if there's been an indictment or some sort of bill of information issued. Um, because it's easier for us to investigate it once we already kind of know what the parameters are. So the answer to that is both. There is the ability for the board to refer that matter, but we often see it as having already come through some sort of criminal prosecution.
But
But
let me
it's
ask you
not
a quick.
something,
Oh, go.
sorry, it's not something the staff can do on its own. It would take a board vote in order to refer it.
You're correct. No, the
Okay.
staff does not move any matters on its own. Everything goes through the board's decisions.
Let me just a little bit backwards because you said there were plenty of things that come to y'all that might be public records or open meetings and which are not obviously the same as criminal at all, but you
Right.
kind of don't take action on those because they're not in your jurisdiction. Do y'all do anything with those, like send on
Uh,
information that says, "Hey,
what we,
look, there might be an issue in your jurisdiction, but we can't handle it," or y'all just kind of like, "That's not our deal."
no, what we do is we present those to our board members with a recommendation to refer, say it's a complainant, perhaps to their local district attorney or to the attorney general's office for guidance. We try not to, one, we're not the attorneys, so obviously we're not giving legal guidance to them, but we try to at least put them in contact with the proper office so that they can inquire and perhaps pursue their issues there. So it is something that the board sees regularly. Like I said, we get a number of complaints every month that get routed to another office or get sent to the complainant as far as a response that says
Okay.
you should contact the attorney general.
Okay. Good. I just want to make sure, like,
Yep.
Yeah,
it
we
just
don't
didn't
want
get
we
lost.
don't
Oh,
want
thank,
anybody's
fantastic.
concerns, Stephen, to fall for them to think that it fell on deaf ears. If there's a concern, we try to make sure
Mhm.
at least the loop is closed so that that individual knows where to proceed.
All right, great.
And Jason, sort of along those lines, does the board, I know a lot of these conversations happen in executive session, so I know there are things you probably can't talk about, but are there moments where board members have heard things like through the grapevine? Y'all all know people in your own areas, where y'all hear things that you bring up independently, as a possible, investigation that the board should look into?
Typically, some of us are from small towns, so you hear small town talk. But what you'll see if you're at our meetings, a number of times that member will recuse themselves from the discussion, just for that to make sure there's no input that could sway the board another way, just because we happen to know that case or we're from that town where the question came up.
But a lot of
And
people, I mean, do a lot of people know that y'all are board members and like reach out and say, "Hey, look, I want to put this on your radar."
I haven't had that situation come to me in this past year and all, and I haven't heard of any other member mentioning that. So I think, if there is a case, typically we'll refer it to David, and David will take
That's
it from there and reach out to that individual or whatever. We try to stay, I guess, hands off to make sure that there's no ill will.
Okay.
so that's what I was going to piggyback on is, I've told all the board members this. Yeah, they're a part of their communities. They're part of the governments that are they are situated in. So they probably do get calls or concerns. What we tell them is have those people call our office, and we will have them talk to a staff attorney. They can, discuss those issues and then submit a formal complaint, so that the process remains the same, so that there's no concerns that, an individual board member is maybe picking an issue out. Because again, it takes 10 board members to agree to move something to an investigation. So we try to, if those are happening, what we've seen, is call our office, let us talk it through from a staff attorney position, and we can go from there.
Okay. David, you mentioned the campaign finance law changes. I know we've spent a lot of time talking about ethics changes, and the legislature rewrote that, but they also rewrote all the campaign finance laws too, which is a heavy lift for y'all to have redone all those forms. But the supporters of that legislation said they were trying to more closely mirror federal laws and also protect free speech rights of donors. But generally speaking, what do the changes mean for candidates?
For candidates, one, obviously, there was a number of changes, so all the forms got updated. But what we've seen is most of the changes occurred with the concept of committees. They have created these concepts called leadership committees. They have also created this concept of a joint fundraising agreement. So, from a candidate standpoint, they may be able to enter into a joint fundraising agreement to simplify the process of contributions coming into their campaign fund. Perhaps, if there's an event or some committee that's good at those fundraising events, they may be channeling that those dollars through that fundraising agreement so that the candidate has less work to do. The reporting is still the same from the candidate's viewpoint as far as reporting contributions and expenditures. But it's a matter of those new mechanisms being available to the candidates and as to what's out there. Of course, the leadership packs is a whole new concept of, I guess, a fund, a chest of money that's available to elected officials to use in the pursuit of certain things, such as supporting candidates or things related to that particular office. So it's a lot of higher level, probably campaign finance issues that have been created. So if the candidates have concerns as to whether something works or doesn't work for them, they probably should contact our office first, and so that we can kind of talk them through and what the reporting requirements are, because they are borrowing a lot of concepts from the Federal Election Commission. And I don't know if anybody's ever dealt with them, but that's akin to sort of dealing with the tax code, and they have a number of regulations, and they have decades of those regulations building on each other, and so you have to be careful if you're a candidate of taking advantage of those things, but making sure that they are done correctly.
So, Jason, part of the campaign finance rewrite, it was clearly designed to make things a little bit easier for candidates, elected officials. Um, but it didn't necessarily focus that much on making things more transparent to the public, in that the legislature increased some of the amounts of money that has to be spent or received before it triggers reporting requirements, for example. Did the board have any input on how the campaign finance laws were changed, and were there any concerns that y'all had along the way?
So prior to the legislative session, David asked for some feedback from the board, and we provided some thoughts and concerns and all. But you know, I guess at the end of the day, the legislators make the rules, and we're charged with enforcing them. The dollar limits are where they're at. Myself, a former parish official for 24 years, where I was 24 years ago, if I got a campaign donation compared to what the possibility is nowadays, I guess like everything else, it just goes up, but you still, like David talked about, you still have to report it, and hopefully we continue to see that benefit. But if in a year from now we have opportunity to go back and say, okay, this is what we're seeing, we go back to the legislator with possible input and see if they'll take it under consideration because there's a gap or something that is not working as intended.
Okay. David, we have a question about ethics trainings and whether they're mandated for incoming legislators and other public appointees, and how often, if ever, do they have to update themselves on ethics education?
So for the ethics training, every public servant has to take the training at least once per calendar year. So by December 31st of each year, that an elected official is in office, they have to take the training. And of course, our public servants who are employees take it every year. So they should be doing that annually. They should also be doing that, I believe, within a certain number of days within taking office. So we hopefully see that it's happening annually for all of our elected officials.
And if they are an incoming legislator, do they have to take it before, before they start working as a legislator, or it's just in the same calendar time period?
I believe I'd have to go double check the statute, but I believe there's a certain date, number of days after they take office that it has to be completed and then annually. Um, but I also point out that all of our candidates, legislators as well, are given copies of the summaries of the ethics code when they qualify. So all of that information is given to them. They have access to that at the moment that they qualify for office as well.
Okay. We have another question. From the board's perspective, what are the biggest obstacles it faces in addressing complaints? So that's for you, Jason.
Biggest obstacles. That's a good one. One, just clarity of information, which Dave and his team do a really good job of making sure when a case is presented to us, it's pretty clear. They've done their homework and it's pretty much an exhaustive investigation before it even comes to us. Um, I think we went through a period of transition. David will probably attest to this with the new board members coming on, just making sure that we were consistent with prior um, reporting, and I think we're through that point now, and I think the last probably 2 months we're really seeing the board move together and really, I guess, gotten more efficient and better organized. If that's a good way to put it. Even with the questions we're asking and the cases moving forward.
Okay. Every year, legislators seem to debate some sort of carve out from the ethics code, exemptions for a whole array of things over the years. I'm going to give an example. Most recently, the legislature allowed members and the executive director of the Racing Commission to own racehorses that participate in the races licensed and regulated by the commission. So does the staff, this is a two-part question, so I'll start with David. Does the staff make recommendations to the board about whether to object to such exemptions? It does seem as though um, all that adding those things creates a level of complexity that the ethics staff has to deal with on a regular basis.
Sure. Generally, no, we don't take the staff won't make recommendations regarding any particular exceptions, such as that one you're talking about. We will point out to the board, say if there's a potential exception, okay, we see this, in X number of cases. Perhaps we've dealt with this 5 or 6 times in the last 5 years. So that's how many cases we think would have been affected. We try to present that information to the board. And then, of course, if they would like us to present that information to the legislature as well, just to give some context to maybe how many potential cases you're talking about being involved. But we have seen the board get involved, or at least present information for exceptions. One recently was for outside employment for certain elected officials. The board had an exceptions that were kind of put together by the board, and then we said, well, the legislature should be the one really putting this together, and so they kind of mirrored that. So what we're doing, typically the board will not take a support or oppose position. Like Jason said, it's up to the legislature to decide what policies they want to pursue and how they do that. But we just point out administrative issues with them, and whether we think it would affect, an ongoing case. Perhaps we have something under investigation that it may shut down. And then, of course, any future cases, or at least explain how we would enforce that position and what information we would need from our public servants to make sure that they understand the new exception. So it's kind of a back and forth, but we try to just provide as much information as possible.
Well, and David may have answered this, Jason, but I was going to ask, like, does the board ever intervene and say that y'all don't like an exception that is proposed? And is there any set of circumstances where board members would go directly to the legislature to testify about any of this?
To my knowledge, no, Melinda. We again, they allowed us opportunity prior to this past legislative session to provide feedback on some of the proposed changes, which we did. David actually went before the subcommittee and all, but other than that, we don't.
Is that something you would like to see change, or do you think that's the appropriate role for the board to have?
I think it's an appropriate role, but I think how do we, if there's opportunity for us to make something better or more transparent or easier for everyone to comply with, I think that feedback should be given and hopefully taken into consideration by the legislatures.
Okay.
I'll generally point out PAR is generally looks at these exceptions
Yeah.
with a jaundiced eye. However, there are exceptions like giving cookies to your teacher. We're like, okay,
Hmm.
we got that one.
Yeah.
And sometimes they're necessary to have exceptions, but we always try to work with the authors to see if we can find the least offensive way to do it possible. So I just want to make sure people understood we are not an absolutist, but we try to work with people. But though we got a lot of exceptions up in there.
Mhm.
Um, David, this is a question for you. What is the size and composition of the staff at the ethics office? I know y'all are always drowning in work, so can you talk about the challenges there?
Sure. So we have included myself for 41 total employees when we were full staffed. Obviously, like I said, we deal with ethics, campaign finance, and lobbying. So our staff kind of gets broken down into each section or each theme. Um, some of the challenges, obviously, we deal with almost, I would say, we do over 200,000 trainings per year. We have one dedicated training employee. We deal with upwards of almost 40,000 different financial disclosures that are filed, either campaign finance or the public financial disclosure reports. So the bulk of our time and our staff's time is spent on compliance and making sure that those are filed. And when they're not filed correctly, that we are responding and trying to respond timely. Um, so that's where we see a lot of the hardship, obviously, of any state agency. I think every state agency tell you they would love more budget to be able to expand some of their duties and perhaps increase the workload, spread it out some. But our staff does a good job handling their tasks that they're assigned, and so there's a recognition though that they are processing a huge number of forms and reports that are filed with our office, and those all require some sort of manual oversight at least to make sure they're filed properly or make sure they're signed. And so it's quite a monumental task to keep up with that. And then, of course, from the investigative standpoint, we have 6 or 7 investigators who cover every corner of the state, from Northwest all the way up to the Arkansas border down to the Gulf. And so being able to handle their caseload, and they are essentially the ones that are going out and interacting with our local officials and our respondents and making sure they're doing that professionally is their biggest job, and they do a good job of it. So we take all that together, and the attorneys here present it to the board, and we're appreciative of Chairman Amato and the board's support for our what we do, and we're always looking for new ways to maybe use technology to update it to make us more expedient. And just to make sure that whoever we're dealing with understands the process and they can have some sense of belief that they're getting at least a fair understanding of what they're dealing with.
And Melinda, if I may, I'll
Yes.
tell the work that Dave and them do. I guess in my 24 years that I was a public official in St. James Parish, I guess I was always in compliance. So I knew there was a board of ethics and all, but it wasn't until January when I came onto the board. And I guess I looked behind the curtain and saw David and his entire team and realized, wow, that we have a tremendous amount of people doing some really good work day in and day out all across the state, as David says. And it's been impressive for me to watch them handle the business. And just recently, all the changes coming out of the legislative session, it, I'm very proud of them.
Sure, that's good to hear for
Hmm.
David.
That's good.
Hmm.
Always.
Good job, David. If I could jump in, I want to ask a question. this is actually a public records question, but yeah, I know y'all have the ethics board, but this actually affects
Mhm.
y'all. So recently, the lawmakers changed some of the public records laws to allow a long list of officials, judges, statewide elected officials, legislators, district attorneys, to remove some public information, some private information about them, like home and work addresses and other information along those lines. If publicly available websites from those websites, if those officials request, and some judges have already started asking for that. So two things. How does that affect your disclosure for forms in terms of some of the forms that y'all are asking? Because some of that is available on your websites. Uh,
Mhm.
and then related to that, and it seems like it'd be more difficult for the public to track some of the campaign spending and other areas of influence. So one is sort of a just technical question, probably more for
Mhm.
David, and the second one is sort of a broader. This is going to mean less transparency on some of these key issues in terms of who's spending what where. So maybe David, you could start off the technical part.
Sure. So we have been asked about that issue based on I think that law went into effect in February of this year. What we have done is we have received requests. Actually have requested guidance from the Attorney General as to what exactly satisfies that redaction process. The law indicates that it can't be published on our website, but does that also require us to remove it from the databases that compile? Say you click on one of our website things about all of the expenditures for a certain time period. That's not displayed on the report, but it's information that can be compiled and compulated. So are we required to remove that information from those sorts of um, underlying searches and different things that you can do with the information that we have available? And then, of course, how much? If we're removing, say, the residential addresses, is it just the street address? Can we leave the city and parish so that people can match, say, a contributor with a common name that might be in different places in the state, so that they know exactly who's giving money to which candidate. Those are
Like,
some of the
like,
things.
like, what if there's a Joe Smith? Like, how do you determine which Joe Smith is
uh,
giving the donation?
Correct. And from an administrative standpoint, if we're looking at are there excessive contributions? Well, if you have four different Joe Smiths with all of the addresses redacted, well, it's hard for us to know whether those are for allowed contributions or are they all one where it's excessive. So those are the sorts of things that I think the public is interested in, and that's some of the concerns: is what information are we redacting or being is the law forcing us to redact, and then still accomplishing the disclosure part of the Campaign Finance Disclosure Act, putting that information out there for the public. And so, from the technical standpoint, there's been a lot of questions as to how we accomplish that. We have asked the Attorney General for some guidance, but we're still waiting on that response. I've seen that. I think the Secretary of State kind of removed themselves from that bill through some language. I think that may be something that our board discusses with the upcoming session as to whether that's appropriate as well. Because the other part of that is, like you mentioned, staff workload. That bill is about to expand, or that act is about to expand to a large number of other former public officials, and we have concerns internally as to our staff's ability and the workload to do all of that. There are a number of concerns with just accomplishing kind of what the intent of that bill or that statute is.
Jason, yeah, your perspective on the bill, and its workability, and also any concerns you might have.
Yeah, similar concerns to what David talked about. And I think the benefit of the diversity of our board was able to weigh in on their thoughts too. That kind of helped David and them. Hey, I think we all came to the agreement. We need some help from the AG to move forward on this, and so I think we taking the right step, but we recognize it's a red flag as a caution for us moving forward.
Okay, great.
I'm just going to point out, in the spirit of transparency and accountability, that the expansion of that law to include all these extra officials, hundreds, if not thousands of people, including legislators, DAs, people who work for the DA's office, it was done in an amendment on the floor, and there was no debate in committee or testimony on it. So there wasn't a lot of time to air any of these concerns in the process.
What an excellent point, Melinda.
So with that, we have one other question in the queue. Is somebody asking about this topic? Wouldn't they be donating as a private person, not a public official, so their contribution shouldn't be subject to disclosure? But that's not exactly accurate because if you make a contribution to a candidate, that's all disclosed, correct, David?
Correct. So the Campaign Finance Disclosure Act isn't concerned with your status as a public servant. It's every contributor is once they meet that threshold amount for a candidate has to be reported, and so their information is provided.
Okay. We're getting close to the end, but I do want to ask both of you, what's a common misunderstanding about the Ethics Board and the Ethics Administration Office in terms of what y'all have encountered from people? Because I think people have no real concept of what y'all oversee and what you don't. Jason, let me start with you.
Okay, all right. Yeah, sometimes I think we're the bad guys. That's what it's perceived as, and I don't. Uh, Definitely in the year that I've been on board, I don't see that. One of the things Dave and I really have been working hard on is outreach to all the different organizations, the Louisiana Municipal Association, Service Association, School Board Association, you name it, the boards and commissions. We really want everybody to be in compliance. And I think letting them know that, we're on your side and we're here to help you. David talked about, all the changes with campaign finance, and we tell any candidate, don't hesitate to call our office. Our campaign finance department does a wonderful job, and they'll walk you through any of your questions, how the forms are filled out. I've had experience with them when I was still in office, and they do a wonderful job. So my focus is really helping everyone know that we're ready to partner with you and we want you to be successful. And I would love for the day that one day David's going to say, Jason, we don't have a meeting this month because we have no cases. I know it's pretty ambitious, but we're shooting for the stars.
Okay, David, what do you encounter as the most common misunderstanding?
I think a lot of people are just familiar with us because of that 1 hour training they have to take. But anytime you're dealing with enforcement against individuals, there's this, probably this idea that maybe we're not being fair to them, or it's they didn't mean to do something. What we tell everybody is we can we can help you before it happens a lot easier than after it happens. So contact our office. Our attorneys are great. They will talk you through every issue. We will advise you to submit an advisory opinion so the board can approve or disapprove of some action that you're going to take. Because if you do it beforehand, there's no penalties. It's simply you can or cannot do something. Once that decision is made and some act is taken, and now we're looking at enforcement, I think a lot of people think we are this big bad enforcement agency. But what we try to do is get the facts straight and then present it to the board so they can make a decision as to the appropriate enforcement actions. And it is like Jason said earlier in the webinar, there's over 200,000 people that take our training. So in theory, all of those are public servants. We see such a small percentage of public servants that have to deal with enforcement issues that it's important for everyone to remember that, I think we're doing a good job of getting that information out there and then honing in on what the actual issues are and making sure that the enforcement is there. But also the board does a good job of explaining, each step of that enforcement and why it is an issue or not an issue. And so we try to do that in a way that everybody can understand. But I think there's probably a reluctance to jump into that sometimes, but that's understandable. But what we're trying to do is make ourselves available to our public servants.
Well, someone just submitted in the chat, thanks for the work you do. So somebody is grateful out there.
Well, one quick question to sort of wrap up. Has the ethics board, working with their staff, started to develop recommendations for the next legislative session?
We will be presenting that probably at the January meeting. I'm putting together some kind of throughout the year. We hit on issues that might pop up, and then I'll present those probably at the January meeting for the board to consider at with an open public discussion so that we can have that. Everybody can be involved.
So no sneak preview right now?
Nothing right now.
I had to ask. So
we've been so focused on getting everything else updated from the last session. So
Okay. Thank y'all both so much. I really appreciate the time. And you can tell from the number and quality of the questions, a lot of people really care about this issue and they really want to know more. So I appreciate y'all taking the time to come and talk to us and help explain some of these things. I really want to thank everyone that joined us today and put in the questions and just took the time to find out more about this important subject. I want everyone to have a great weekend. This will be just a reminder, we will put this on our YouTube channel so other people will be able to do this. You can share this with your friends and neighbors and make sure they know more about this as well. Thank y'all. Y'all have a really good weekend.
Yeah, happy Thanksgiving.